Hi friends, welcome back to Legalopolis. In today's video, we'll be diving into a crucial aspect of US immigration, the concept of dual intent visas. A good understanding of dual intent is key to successfully navigating the US immigration landscape. In this video, we'll explore number 1, what dual intent means, number 2, which visas fall under the category of dual intent, and number 3, which visas don't fall under the dual intent category and what it means for you. So, if you're curious about the pathways to balancing short term plans and long term goals in the United States, you are in the right place. Let's get started. Now, friends, what does dual intent mean? Dual intent is a legal concept in US immigration law that allows individuals on certain non immigrant visas to number 1, hold and maintain a temporary non immigrant visa, and number 2, have an intent to immigrate. So, to simplify, dual intent is a concept in US immigration law that allows non immigrant visa holders in certain visa categories to express their ambition to eventually secure permanent residency while currently residing in the United States on a temporary visa. And therefore, individuals with dual intent will be all those people who are at the present moment in the United States on a temporary visa, and number 2, they also have the desire to eventually become permanent residents. Now, friends, how is it different from other non-immigrant visas? Now, as we have understood, a dual intent visa is a special type of non-immigrant visa issued by United States that allows foreign nationals to temporarily reside and work in the United States while also granting them the option to pursue permanent residency, that is, green card in the future. This is in contrast to most other non-immigrant visas, where applicants generally need to demonstrate a strong intention to return to their home country after their stay in the United States. Dual intent visa offers flexibility and a potential pathway to permanent residency for certain individuals with valuable skills or circumstances. And that's why those visa categories are considered as dual intent visas. They do not have to show strong ties to their home country at the time of interview, whereas for all other non-immigrant visa categories, absence of strong ties to home country will result in a visa denial under Section 214B of the Nationality and Immigration Act. Now let's look at which visas fall under the category of dual intent. Number 1, H-1B visa. These are specialty occupations and their dependents, H-4 visa holders. Number 2, L-1 visa holders, that is, intra-company transfers and also their dependents. O-1 visa, that is, aliens with extraordinary ability, and K visas, that is, fiancé and spouses of US citizens. Now, friends, let's look at visas which do not allow dual intent. Now, first, let's make it clear, not allowing dual intent means that the visa applicant at the time of the interview must demonstrate, number 1, their eligibility for non-immigrant visa category for which they've applied for by providing detailed evidence and information to support their case. And number 2, they have to show strong ties to their home country. Because in order to dispel any presumption of immigrant intent, it is crucial to demonstrate your deep connections to your home country. By establishing strong ties, you will be able to convince and assure the consular officer that you have genuine and compelling reasons and personal commitment to return to your home country after your temporary stay in the United States is over. Any absence of these will result in your visa being denied. Therefore, all individuals who are on non-dual intent visa are expected to return back to their home country once the term of their visa expires. These visas are number 1, B1 and B2 visa, that is visitor for business purposes or tourism purposes. TN visa. TN visa, also known as NAFTA professional visa, is a non-immigrant visa specially designed for citizens of Canada and Mexico who want to work in the United States in pre-arranged professional occupations. H-1B1 visa. This is a specific type of non-immigrant visa issued by the United States that allows citizens of Chile and Singapore to work in specialty occupations in the United States on a temporary basis. H-2A visa. These are temporary agricultural jobs in the United States for which US workers are not available. H-2B visa are temporary non-agricultural jobs in the United States for which again US workers are not available. H-3 visa. H-3 visa allows foreign nationals to come to the United States for short-term non-medical training which is unavailable in their home country or to participate in special education exchange programs. E1, E2 and E3 visas which are treaty trade visas, and then comes F1, J1, M1 visas. These visas allow non-immigrants to study in the US with F1 for academic programs, J1 for exchange programs, and M1 for vocational schools, all with different employment and duration limitations. So, my friends, to wrap things up, having a solid grasp of dual intent is essential when navigating the realm of non immigrant visas in the United States. Whether you are at the interview stage or applying for a change of status within the United States towards permanent residency, this understanding is critical as it profoundly influences your potential path to permanent residency. Notably, visas such as H-1B and L explicitly permit dual intent. But as we just discussed, other non-immigrant visa categories demand thoughtful consideration. Choosing the right visa and right path is pivotal, especially if your ultimate goal is securing permanent residence. So friends, I hope this video has been helpful for you, especially if you're in the process of applying for your visa or green card. May your application be met with success. Thank you so much for your time, and I look forward to seeing you soon with another video. Until then, safe travels!